all of this week, certainly, guys, and for next week, part of it, we will still be working in the areas of contract law. We will, after we have contract law completed, we will be moving into the area of employment law. And once we have our employment law section of the course done, that will bring us to a close then in terms of our studies in business law. Now, last Tuesday in class, we focused on the rules of contract law. Specifically, we looked at consideration and we looked at the intention to create legal relations. And there's just a few things, guys, in that question booklet that I want to run through with you. So if you wouldn't mind, if you have your question booklet handy, or if you want to actually use the one from Moodle, be great. I'm going to share the screen with you anyway, but I just want to go through a few questions with you here so that you can, so that we can make sense of it, so that we have a fair understanding of the rules. Okay, now, so I've shared it there with you folks, and the first question here, we're looking at question 1 on page, what page is that? Page 19. So question 1, page 19. Now, this question says, in the context of contractual consideration, explain whether Peter is obliged to fulfill his contractual promises in the following situations. You should rely on the relevant rules of consideration to support your conclusions. Now, guys, bearing in mind that you are going to have an assessment at the end of the semester, an assessment that's worth 80%. In that assessment, it'll be an exam style assessment that you'll be getting, and you'll have a limited amount of time to answer the questions, and it'll be available to you online. That'll come at the end of the semester. Bearing in mind the nature of the assessment that you're going to get in December, guys, it would be good practice for you now at this stage to start answering questions, and to start answering questions well, getting into the habit of answering questions and thinking about the answers, thinking about a good answer and all the rest of it. I don't have sample answers for these questions, but I'll go through them with you as best I can in class. Your third year, some of you will exit the course this year, and some of you will exit the course next year. But given the level you're at in your course at this stage, guys, of course you'll understand that your answers should be of a high standard, and that your answers should contain the relevant details, and that you should articulate the concepts, the principles, the rules concisely, and that you should use good, solid, relevant information to support your arguments, and that you come to well-reasoned conclusions. Now, if we just look at this question here, question 1, and in the context of contractual consideration, explain whether Peter is obliged to fulfill his contractual promise in the following situations. Okay, guys, so explain whether Peter is obliged to fulfill his contractual promises. Don't say yep or nope, okay? Those type of answers, like, guys, with the best will in the world, I don't think at this level, those type of answers really would fit the bill. Could you imagine yep and nope? Like, put yourself in a work situation and your employer asking you something, and you write a report back to them and you say yes or no back to them. I don't think that it would necessarily be the acceptable thing to do. So you have to rely on the relevant rules of consideration to support your conclusions here. And part A, Peter promises to sell an expensive car worth 50,000 euro to Alex for 50. So gosh, Alex is getting the bargain of his life here, getting this, obviously a very luxury or a very classic car, and he's getting it for 50 euros. So Alex is certainly getting a good deal. Now, if you were answering this question in an exam situation, I don't need you to go into the to the merits or to give a description on the fairness or the unfairness of it from whichever party side you're taking. That's not what is required there at all. He promises to sell an expensive car to Alex for €50, and the car is worth a lot more. What I would expect a student to do in answering this question is to talk about the relevant rule from the point of view of contract law and consideration. You don't need to go into offer and acceptance there, because they've just said, in the context of contractual consideration, explain whether Peter is obliged to fulfil his contractual promises, and you should rely on the relevant rules of consideration. So what I would suggest, and the approach that I would take there, is to identify the relevant rule. What rule is in question? Is it consideration must not be passed? Is it consideration must be sufficient but need not be adequate? Or is it that consideration must move from the promisee? Which of the three is it there, folks? Is it consideration must not be passed, consideration must be sufficient but need not be adequate, or is it that consideration must move from the promisee? There's one rule at play there in part A. Which rule is it, guys? If you're shy, put it in the chat. Otherwise, I'd like to hear from you. Anyone of the three rules that I listed, guys? I think one of them is relevant. Okay, is anybody going to answer the question? Okay, no, that isn't the correct one. So a message has come in the chat that it's a consideration must not be passed. No, that's not the right one. And yes, as a couple of people are coming into the chat now, fantastic, good guys, very good. The consideration must be sufficient but need not be adequate. Thank you and well done to the people who are contributing in the chat. That's great, it's really appreciated. So what I would do there, folks, in answering that question is I would mention that rule, that consideration must be sufficient, need not be adequate, and I would explain the rule. Am I looking for case law? Absolutely. So I expect you to explain the rule and explain that the law isn't concerned with whether or not Peter or Alex got a good bargain. The law is only concerned with ensuring that there is a minimum exchange present. I would refer to relevant case law. The relevant case law that might be useful here about consideration must be sufficient but need not be adequate. Tanner would be a good case to refer to, where she was allowed to live in a house for £1 a year, and that was deemed to be valid consideration. And similarly in Chappelle and Nestle, where the used chocolate bar wrappings were found to be valid consideration. And I would talk about the rules, talk about the case law, and then I'd say, is Peter obliged? So under the rules of contract law and consideration, it appears that following the rule, Peter would be obliged to sell that car to Alex for the €50. Okay, well done, guys. Thanks for everyone for their contributions there in part A. In part B, Peter returns home to find that his house windows have been cleaned by Barry, and he promises to pay Barry €30. Okay. Which rule of consideration is at play here? Is it, again, consideration must be sufficient but need not be adequate? Could it be that rule? Or could it be that consideration should move from the promisee? Or could it be that consideration must not be in the past? Would it be any of those three rules? Any thoughts? Okay, very good. Thanks, guys. Well done to those of you who are contributing in the chat. Yeah, past consideration won't bind a new agreement. So we would explain the rule here again, explain that you need a fresh consideration to support a new promise, refer to your case law, good cases that you'd mention here would be Ross Corla and Thomas, where the promise was that the horse was free from vice, but it turned out that no consideration had actually been given for that promise that the horse was free from vice. And you could also refer to the case of MacArdle. And in the case of MacArdle, lady had carried out improvements to her family home, the in-laws' family home, and subsequently the in-laws promised to reimburse her. And then they didn't, and she sued, and it was held that there was no consideration given for their promise to actually pay her because the improvements had predated the agreement to actually pay her. So it was old consideration there. Okay, very good. Well done there. And just a point to note about using cases, that if it is a thing that you are, well, you will be using cases when you're doing your answers here in business law, when you're using the cases. And a legitimate question that a student will sometimes ask is it okay if I just put down the name of the case? And no, that's not what you're supposed to do. The idea is that you provide the name of the case, but that you also outline what the principle of the case is and why the case is important, or what rule the case illustrates. So like, for example, you used MacArdle there to illustrate that past consideration is not good consideration. Okay, so outline the principle of the case and outline the significance of the case in terms of what the case actually illustrates. Now, question 2 is a very straightforward question in that you're told what rule is under discussion. Discuss the rule that consideration must be sufficient but need not be adequate. Okay, so we've already talked about that rule, folks, so I won't labor the point there. Question 3, explain the statement that forbearance may provide sufficient consideration. Like if you are giving up all of those things which you're legally entitled to do, that can amount to valid consideration. We looked at this rule in the context of cases last week, like Hammer and Sidway, where an uncle promised his nephew that if he gave up drinking, smoking, gambling and all that, or didn't do it until he was 21, he'd pay him money. That was held to be valid consideration. So always, the advice I'm giving you today, guys, is that when you're answering these questions, that it's important to identify the rule and it's important to explain it. So I should actually explain the principle in question. Explain precisely what the principle of law actually is and supports that in your cases. Now, if we look at question 4, Danny is one of 12 builders working on a project for Construct Zone Limited. It is agreed between Construct Zone Limited and each of the 12 builders that they will each be paid €12,000 for the work and that the building work must be complete within 6 months. 2 months into the job, 4 of the 12 builders leave to emigrate, and Danny is one of the 8 remaining builders left to finish the job within the time agreed, 4 men down. And Construct Zone Limited promises each of the remaining 8 men 3,000 extra to complete the job. Danny and the 7 other builders work flat out and get the job done within the specified time period. However, when they have the job done, Construct Zone Limited refuses to honour its promise of the extra €3,000 each, claiming that the builders provided no consideration for that promise and that the company is therefore not under any obligation to pay it. Danny thinks this is grossly unfair and has come to you for advice. So in light of relevant case law and academic commentary, advise Danny as to whether he is entitled to the extra €3,000 promised. Any thoughts from anyone out there about whether Danny is entitled to this extra payment? What do you think? Is Danny entitled to this money? Not entitled to this money? He was promised this money. Danny and the others were promised this money. Are they entitled to it? Okay. Okay, so there's various comments are coming into me in the chat. So one comment that has just come in is that that Danny wouldn't be entitled to it because there was already an existing promise in place. So therefore, Danny wouldn't be entitled to it. Somebody else has just echoed the same thing and said that it falls under a promise to perform an existing obligation. So they've echoed the same thing. There's a third comment there that no, a promise to perform an existing obligation is not valid. Okay, very good. And I have somebody else saying that promise to perform existing obligation isn't valid. Another comment has come in and said, yep, €3,000 is new consideration for the extra work required to avoid penalty. Very good. Okay. Somebody else has also said, yes, they are, but they haven't given me any justification. So justification as to why they're entitled to it would be good, so that I can actually reason it. Okay, now folks, this question is, the facts of it are kind of, but not identical. They're kind of similar to it's kind of similar to Stilk and Myrek. And Stilk and Myrek, and I'm just going to put that in the chat so that you can actually look it up. So Stilk and Myrek, and in Stilk and Myrek, remember that what happened there? The guys deserted the ship, and the ones that stayed on the ship were promised to be paid extra, but when they got home, they didn't get anything, and they were told that they were already contractually obliged to do something, and therefore they hadn't provided any extra consideration. Now, in this situation that we have here with Danny and Construct Zone, that rule will absolutely apply, that they're already under an existing obligation. They're already under an existing obligation to do something, that there is a contract in place. And the terms of that contract are that they'll be paid 12,000 for the work, and the work is to be done within 6 months. So the lawyers for Construct Zone are going to argue that no, Danny isn't entitled to it because there's already an existing contractual obligation, and they've done no more, and Danny hasn't done any more, therefore he's not entitled to the extra 3,000. Now, lawyers for Danny are probably going to argue that does it not come within the terms of Williams and Roffey brothers? And Williams and Roffey brothers is that if there's a practical benefit obtained and there's no economic duress or undue influence, that Danny would be entitled to the extra amount. So I suppose Construct Zone Limited have got a benefit in that the work has been completed, has been absolutely completed on time. I don't know what penalty they have avoided. So it's not quite clear cut here in this case. But what I would be advising in my answer is I would be referring to the rule that performance of an existing contractual obligation is not valid. And I'd also refer to Williams and Roffey Brothers. It might be that there's more information required to fully answer the question. We don't know what agreement Construct Zone had, whether they had some other agreements that they were going to be penalised or that would be a penalty clause if they didn't have if they didn't do it by a certain date. Okay, and you can only advise as best you can within the legal principles that are that are there and are available to you. Somebody has asked me there in the chat, could I advise on how many marks would be available for this question? This question is the style of a previous exam question. So this would have been a full question, and business law exam papers have been 3 questions, so 33 1/3 marks would have been going for these questions. So that we this one here with Danny was a full question. There's an MCQ there, guys, that you can look at yourselves, and then I just look at one more question that I want to look at with you, and then we'll leave it, folks. This one here on page, what we're on now, we're on page 22. This question here on Colm, and this was a previous exam question. That Colm is a season ticket holder for the Leinster rugby team. David is a handyman who is doing some work installing a home cinema system in Colm's home for €300. The work takes 2 days to complete. In the following week, and being so impressed with the work, Colm tells David that he will give him his tickets for the upcoming Leinster and Munster game for the work he has done. And based on this statement, David books a hotel room and restaurant in Limerick for the night of the game. And on the night of the game, Colm refuses to give David tickets. So we had to advise David if he can legally demand Colm to give him the rugby tickets by discussing the law in relation to contractual consideration. Right, folks, any rule there that you think could be relevant? Would you say it's that performance of an existing legal duty is not valid? Would you say it's that consideration has to move from the promisee? Consideration must be sufficient but need not be adequate? Would you say that it's consideration must not be passed? Or would you say that it's the performance of an existing obligation? What rule or rules even do you think might be relevant here to advise David? David wants to know if Colm has to give him these tickets based on the rules of contractual consideration. Any rule relevant there, folks? No rule? Any rule relevant? Very good. Yeah. Okay. The relevant rule that would be appropriate to discuss here in this question again would be the rule on past consideration. That would be a good starting place in advising David if he can demand Colm to give him the rugby tickets. So referring to those rules there on contractual consideration, talking about past consideration is not good consideration, and referring to case law. So yep, important to explain the rule, identify the rule, explain the rule, okay? And it's important then that you would illustrate the application of the rule as from case law. Question that you might want to know is, can it be a case that we didn't cover in class? Yeah, you can refer to a case we didn't study in class, provided it's a well-known case and it's a real case. And if you get stuck and if you can't remember the case or the case's name, do your best and illustrate the rule by reference to an appropriate example. All right, now folks, we're going to move on and we are going to start looking now at what we are going to start looking at now are the rules on with respect to the terms of a contract, and we'll start looking at the rules with respect to sorry, now I'm just trying to share my document, just bear with me. No, sorry, folks. Zoom playing tricks on me there as I was trying to share this with you. Okay, so I think I'm sharing it with you now. I'm sharing on the contents of a contract. Right. So the last topics that we've been looking at, folks, have looked at the essential elements of a contract. In other words, we've looked at the 4 things a contract has to contain, which are there must be offer, there must be acceptance, there must be consideration, and there must be that intention to actually create legal relations. Now we're going to look at some of the other elements that might be part of the contract. We're going to look at such things as those contracts that have to be in writing, and those contracts which have to be evidenced in writing. Any contract will have terms and conditions. Like if it's a contract for the purchase and supply of a coffee, there'll be terms and conditions to that contract. And obviously, the terms and conditions of your contract will always vary depending upon the type of contract in question. And some contracts are going to contain exemption clauses. Now, exemption clauses, folks, are clauses which limit liability. I'm not going to get to exemption clauses today. It will be tomorrow before I get the work done on the exemption clauses. So what you should be able to go away with this evening is that you should be able to say, well, what type of contract has to be in writing? Has to be in writing in order for it to be enforceable. And maybe we'll get to look at the differences between terms and representations as well. Okay, so generally, folks, when it comes to making contracts, there's no formalities required. All that's required is that you have those essential items or essential elements, that you have your offer, acceptance, consideration, and you have intention. Okay, and we all make contracts regularly without even thinking about that we're making contracts. And it's a matter for the parties as to their contract, the terms and conditions of their contract, and what they want to negotiate about, and how they want to carry their contract. Do they want it in writing, or are they content to leave the contract to be orally? But there are some exceptions where the law does require some formality, and without these formalities actually being achieved, the contract won't be enforceable. It'll be difficult to sue on it, in other words, and the court won't be too indulgent towards your claim. So some of these contracts are contracts by deed or under seal. A deed of conveyance is a contract that has to be in writing. In other words, when there's a transfer of land, that'll be a contract by deed. Or for those of you who are studying tax, a deed of covenant for tax purposes, that has to be in writing. And whenever title to land is being transferred, some exceptions, contracts which must be in writing, and then there's contracts which must actually be evidenced in writing. So a contract by deed, and this would be a contract, for example, a deed of covenant or a conveyance of title. And these type of contracts, they're not supported by consideration, and they have to be in the form of a deed. And what is a deed? And you'll often hear people talk about the title deeds to a house or the title deeds to property. And the deeds are, or a deed is a written document, and the essentials of it are that it's signed by the contracting parties, it's impressed with the seal, and it's delivered by the person executing the deed. In other words, the person signing it actually is handing it over to the other party. Okay? And contracts then that must be in writing. So these are the type of contracts that have to actually be in writing. They're mainly commercial. And who says that they must be in writing? Legislation. It's actually the legislation that's saying that they have to be in the form of a written document. So it's not me that's saying it. It's not some other academic that's saying it. It's the legislation that provides that these type of contracts must be in writing. And why? Why do these contracts have to be in writing? And if you look at the types of contract that are involved, these types of contract are, for example, credit sales, lease agreements, transactions under the Consumer Credit Act. For protection of the consumer, they have to be in writing, and also for reasons of proof. And the attitude of the law is that if these contracts aren't actually in writing, that they will not be legally binding. So credit sales would include your guarantees, would include your loans, would include your mortgages. They all have to be in writing. These type of contracts have to be in writing. Okay, and if it's a lease of land for more than a year, DC's Act 1860 still applies. Okay, I know you're probably thinking that is ancient. How could that still be relevant law? But yeah, the lease still has to be in writing. So a lease when it's of more than 1 year. So when you're trying to make sense of it, guys, then and trying to think of those contracts that must be in writing, they are your contracts, commercial contracts generally, and ones that protect the consumer. Then you also have contracts that don't have to be in writing, but have to be evidenced in writing to be enforceable in a court of law. Okay, there needs to be evidence of certain types of contracts in order for these contracts to be enforceable in a court of law. So according to the Statute of Frauds, it requires certain contracts to be evidenced in writing. And again, why? Why does the Statute of Frauds Act of 1695 require certain contracts to be evidenced in writing? It's to defeat fraud. How? To defeat fraud in situations where parties would make an oral contract and one party then would later actually deny it. Okay? So this statute of frauds, where it has a requirement that contracts should actually be evidenced in writing, it's not requiring that the contract itself is in writing, but rather that there is written evidence of the contract. And the statute of frauds says that the types of contracts which must be evidenced in writing are contracts for the sale of land or any interest in land. So a contract for the sale of land or any interest in land, that has to be evidenced in writing. Or it could be a contract of guarantee, you know, when a person is promising to pay the debts or to pledge the debts of another person. Contract made in consideration of marriage, and contracts that are not to be performed within 1 year. What would an example of a contract that's not to be performed within 1 year? That could be like tenders that are used by builders. But the most important thing here, guys, from what we're looking at here and what's in front of you, is that these type of contracts have to be evidenced in writing. That's what the law says. So what does the statute of fraud says? The statute of fraud says is that there must be written evidence of the contract by way of some type of note or some type of memorandum. So if you even read the legislation there, it says that no legal action can be brought to enforce these contracts. So in other words, you can't initiate legal action in the courts. You can't bring the case before the courts unless the agreement upon which such action shall be brought or some memorandum or note thereof shall be in writing and signed by the party to be charged or some other person thereunto by him lawfully authorized. So what this means is that there must be some written evidence of the contract by way of a note, a memorandum. That's what the statute of frauds is saying. That if you're going to look for the relief and help of the court, there must be some memorandum or note in writing, and it should be signed by the person or some other person lawfully authorized. So that could be his solicitor, that could be the auctioneer who has the authority to actually make the signatory. And that memorandum or note has to contain the relevant P's. In other words, the party, the property, the price, and any other particulars. Okay, so contracts that are evidenced in writing. What would an example of a contract that has to be evidenced in writing? That would be a contract for the sale of land. There has to be evidence in writing of that, and it should be in some kind of a note or some kind of a memorandum, and it should contain the basic details of who are the parties, in other words, the relevant persons to this agreement or contract. The property, is it 44 Main Street? Is it 66? Is it 66 High Street? And the price, the consideration that has actually provided. And it can be that the note or memorandum mightn't even have been created especially to comply with the statute. And over the years, case law over the years has accepted a variety of documents as suitable memorandums. So case law has accepted correspondence from solicitors, correspondence from estate agents, receipts, checks, etc. All documents that provide evidence of the contract. So all of these things, like the email whereby something is acknowledged, could be sufficient to satisfy the statute of frauds, and similarly a letter, receipts, etc. Now, a question has just come up into the chat, and I'll take the question in a moment, and I will get back to that question. Subject to contract. If you have documentation and it says subject contract, that means that the full terms of the contract haven't been agreed yet. You don't actually have a binding contract at that stage. And for example, if you were in business and you had spotted, this marvelous property that you wanted to run your business from, and you're corresponding with the other side, you're corresponding with the vendors, and in the correspondence it's headed subject to contract. That confirms that there is no contract in place. And whenever you use the words subject to contract on documentation, that shows that it's not yet intended to be bound by the terms until the final contract has been concluded. So where the words subject to contract are used, it indicates that there isn't a contract yet, that the full terms of those contracts are yet to be realised, that the full terms of the contract are yet to be negotiated. And the authority for that statement that subject to contract means that you don't actually have a contract comes from this Irish case of Boyle and Lee. And the court held in this case that a written note which says subject to contract denies the existence of a contract and is not a memorandum or a note for the purposes of the statute of frauds. And subject to contract means that no agreement has been concluded because the parties have agreed that they'll not be bound in the absence of a formal contract. As a result, any note which is headed with the phrase cannot constitute a memorandum. Okay, so you can't be brought into contractual relations while that phrase subject contract is used. Now, a question was, there was a question in the chat, and the question said, without a paper trail, no contract exists. Well, now, just to be clear on this, what we're looking at the moment is we're looking at the type of contracts that have to be evidenced in writing, such as a contract for the sale of land. There has to be evidence in writing for that type of contract. Other contracts do not have to be in writing, and the law doesn't require that there is any evidence of them in writing. And I'm sure people are ready to scream at me and say, well, if you don't have your contract in writing, how do you prove it? Yes, I accept that it would be much easier to prove the existence of a contract where there is paper saying that there is a contract, but behaviour and proof can be sufficient to demonstrate the existence of a contract. So just going back then, what you do need to remember there, guys, is that certain contracts are required to be in writing. Hold on, which contracts are required to be in writing? Contracts, credit sales, for example, or leases for more than 1 year. Those type of contracts must actually be in writing. And then you have contracts which must be evidenced in writing. So the contracts which must be evidenced in writing include contracts for the sale of land and contracts of guarantee. They have to be evidenced in writing. So you need documentation to support them. There is this doctrine of partial performance. It's not used too readily, but just, and I'm not going to overly emphasize this, not going to labor on this. Statute of frauds could cause a bit of hardship where you had an oral contract and the contract was partly performed. For example, if A agreed to lease B's house and B got the house ready and B installed a wheelchair ramp for A, and then A changed their mind. If there was no written evidence of it, the fact that B got the house ready, that could be taken as evidence that such an agreement was made. So part performance, this doctrine of partial performance, is going to be relevant where you have an oral contract without written evidence. One party starts to perform the contract and the other would deny the contract ever existed. Usually no note or memorandum, but part performance of the contract by the plaintiff, and the courts developed the doctrine of part performance, and part performance is evidence that the contract was actually performed. So it's not used too often, guys, but just to be kind of semi-aware of it anyway, this doctrine of part performance. Okay, next thing, guys, is terms, representations, conditions, and warranties. Just to say that all terms and conditions of a contract have to be complete and final in order for the contract to be binding. Okay, freedom to contract. The concept of freedom to contract means that parties can choose the terms of their contractual relations. So the parties can choose what the terms of their contract is going to be. That's up to the parties themselves. They choose what the terms of their contract is going to be. Okay, now the terms should be legal, of course. Okay, in some contracts, the terms are going to be very simple, and in other contracts, they'll be far more complex. But the basic principles are the same in all contracts. In other words, the terms are going to state what each party is obliged to do under the contract, and parties are expected to comply with the terms of the contract. Otherwise, they're going to be sued for a breach of contract. So I won't go on to the terms and representations today because I'll only get a tiny bit of it done. So I will do that with you tomorrow, and we're going to look at exclusion clauses then as well in class tomorrow, guys. Okay, so if you have any questions, by all means, raise them with me. I'm happy to take any questions that you might have. And otherwise, thanks for joining, and I'll chat to you tomorrow. Thanks, guys.